The next case is, as we said, Brock versus Cobblestone Park Development, LLC. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
3, please.
3?
3 minutes, please.
Very good, thank you. I'll keep track of that up here. And I will try to let you know when you get to 1 minute left in your initial time. The arguments are being recorded. When you present the argument, please come to the podium. Please make sure you introduce yourself. And try to stay behind the podium because it's video recording and we lose if you go back and forth. And also we lose the microphone if you go back and forth, and we do want you to speak up loud enough so we can hear you and you can be picked up on the recording. I don't know that it's particularly relevant in this case, but if you would be use the name of a child or a victim or anyone, please use initials or designation rather than that. But I don't think, again, in this case, I don't think that really applies. We read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. Good morning. May it please the court, counsel. My name is Robert Keogh, and it's my privilege to appear before you this morning on behalf of the appellants. Briefly, this case involves a development in Medina. My clients are members of the Cobblestone Homeowners Association, and the defendants are the developer, 3 of the former board members, and the property management company, all of which have an inherent conflict of interest because the management company is owned by one of the members of the board. His son, who's a board member, works for the management company, and the developers were 2 of the board members and the same individual that owns the property management company and sits on the board. My clients brought derivative claims. Derivative claims are a unique form of pleading. It's a 6-count complaint, and the derivative claims were brought for and on behalf of the Owners Association because the board members were not going to sue themselves. It's really that simple. So Rule 23.1 has a mechanism where individual members of the association can bring suit. That's what happened in this case. There are a lot of arguments in the briefs. What I'd like to point out to the court is there are 3 overarching themes that impact each one of the assignments of error in each one of the arguments.
Before we get to that, I'm having difficulty understanding the final order. It says it's dismissed as settled, and then it says it's dismissing claims, but it says some of those are settled. So what does this final order say?
Thank you, Your Honor. Almost on cue, you set that up for me, because I was going to say one of the overarching themes is the settlement. So the settlement, there is a signed settlement agreement between the parties. Appellants believe, and I believe the appellees also believe, that there is a settlement of all issues. The non-money issues, which included the resignation of the board members, the turnover of the association, the bank accounts, the assets, was completed in December of 21. The 2 issues that were agreed upon that were executory were the issue of damages and the issue of attorney's fees. Under the Community Association Statute 5312, there are attorney's fees for this type of action. The settlement agreement acknowledges that attorney's fees are due, but the defendants, appellees, reserve the right to challenge the amount. That's fine. Same way with damages. There was a protocol that was put in place that was designed to be efficient. So the parties agreed on exactly what discovery was needed, what documents needed to be turned over by law under the Community Association Statute, what documents need to be retained under the association's declaration and bylaws that needed to be turned over. And that process was supposed to accelerate a determination of the association's financial status.
So the claims were settled within that settlement agreement?
Yes, the claims were settled within this agreement. And what the magistrate agreed to do was continue to work with us. There were 8 pretrial conferences with the magistrate, all designed to address the issue of damages. And
so then how do you dismiss on a 12C claims that are settled?
That's a great question. That is a great question. And so my overarching theme was going to be, there is a signed settlement agreement. That translates to waiver. Waiver impacts each assignment of error and every argument under those assignments of error. Because if you sign the settlement agreement, you agree to resolve all issues. You waive challenges to jurisdiction. You waive challenges to party and interest. You waive all of those challenges. There's another defect here too. The defendants never answered the complaint until just before the trial. But the other overarching theme is what I call the great paradox. And the defendants argue the association needs to be a party. The trial court determined they needed to be a party. We addressed that question. So let's set aside for a moment whether under 23.1, the derivative rule, they need to be a party. Let's assume that they do. We address that by saying in a pleading, we move to amend to add the association as a nominal plaintiff. What does a nominal plaintiff mean? They're listed as a party, but at that point in time, we were not looking to conduct new discovery, we were not looking to add new claims. We were saying, look, you claim there's an issue about whether the association needs to be a party of record. Let's resolve that with an amendment. We also subsequently, when we represented the association, so when this issue first arose, we represented the derivative plaintiffs, not the association. Fast forward a number of weeks, we represent the association, we move to intervene. So we're saying we'll address this one way or the other. We'll amend and add them as a party, we'll move, the court can have them intervene. The court then denies the intervention, denies the amendment, and the great paradox is defendants and court, if you believe they need to be here, we've given you two avenues and you've said no, we're not going to let them in. So on the one hand you say they need to be here, and on the other hand you say we're not going to let them in. I don't know how you resolve that in a settled case. So moving to the first assignment of error, was it error for the court to dismiss the case? Well, yes, it was error. I've talked about some of the issues already. We've got the issue of waiver, and that goes to jurisdiction.
I don't think we have a clear ruling here, that's the issue. It says in one paragraph it's dismissed as settled, and it says in another paragraph it's dismissing claims under 12C without telling us which claims you're talking about, or if the whole complaint is dismissed. Don't we have a contradictory final order here?
I had not considered that, Your Honor, but I would agree with you that to the extent the trial court's order dismisses the claims in a case where they've been settled, you do have a contradiction. I can't argue that that's not the case. So if the trial court's order is to be read as a dismissal under Rule 12, which is a fair reading, they have dismissed a case where the claims have been settled. But then in the same order, there's an invitation to file a motion to enforce or to file a new action, neither of which are
Was the trial court to some extent saying the initial complaint is settled and dismissed, but then you tried to amend, so your amended complaint, we're not going to permit that under the civil rules on this amendment by delineation or whatever it is you were attempting, interlineation, excuse me, you were attempting to do. Would that be a fair reading what the trial court was trying to say in dismissing in 12B? It was just going to your amended motion or your most amended complaint?
I'm not sure I would read it that way, Your Honor. I think what the trial court is doing, honestly, is being deferential to the Supreme Court's 2-year rule and looking for a reason. I think that one of the reasons we're struggling with this is it may have been an outcome-based decision. Nevertheless, we're dealing with it in terms of what's in front of us. And so there is a case that's settled, and there was a motion to amend, to add the association. That was denied. So to the extent that there was an issue raised by the defendants that the trial court latched onto, it was the association needs to be a party. I would argue to the court that they don't need to be, excuse me, a party to the settlement, because we have a settlement, and if the defendants believe, excuse me, that the association needed to be a party, that position was waived when the settlement agreement was signed. So when they entered into the settlement, they said, we have all the parties we need in front of us to make this agreement. Within that settlement, there were two issues that were reserved for court determination if the parties couldn't agree. So that's
Was
what,
that settlement agreement entered and approved and placed on the record in some capacity?
no, it was not. No, it was not. So,
Is it before us on the record somehow at this point? in time?
yes, it's an exhibit to several of the pleadings. Yes, it is. And that agreement, as I mentioned earlier, does contemplate a derivative settlement in a fairness hearing. So to the extent that there's any issue about whether this was a derivative claim, in the complaint itself, there are 6 separate paragraphs where the derivative plaintiffs identify themselves as derivative plaintiffs and state that they are making the claims for the association. So we do not believe that the association needed to be a party in order for the terms of that settlement to be implemented. But in order to address it, if the defendants believed it was necessary, if the trial court believed it was necessary, there were 2 avenues to make that happen. So under Rule 12, when the defendants moved to dismiss, there was an issue. I mean, Rule 12 speaks to delay and just before trial. Well, the motion was made literally days before trial, and obviously here we are, 14, 15 months later. There's clearly been delay. That in and of itself is abuse of discretion. There is a question about whether this Cobblestone case from the 8th District.
You have 1 minute left in your initial time, counsel.
Yes, Your Honor. Cobblestone is not a derivative claim. It does not apply, period. On the third assignment of error spoliation, we learned less than 2 weeks before trial that the key documents that were to have been produced over a year prior were no longer in existence or had been destroyed. It was not unreasonable for us to say at that point in time, there is now a spoliation claim. Literally 2 weeks before that announcement was made in open court by defense counsel, we were told that the documents that had not yet been produced would be produced, quote, with a bow. Well, what we got was nothing, and then at the hearing on February 23rd, we were advised for the first time that those documents no longer exist or they've been destroyed. Not a question of record keeping under the statute, under the Declaration of Bylaws. Those documents had to be retained.
And counsel, your initial time is up. If you
Yes,
want
Your
to
Honor.
continue, that's fine, whatever you'd like to do.
Thank you. I'll retain
Understood.
3 in rebuttal. Thank you.
Good morning, Your Honors. Counsel, my name is John Ebker, and I'm here on behalf of 2 of the defendants, Bud Tetzlaff and his son Eric Tetzlaff. I'm joined by Leslie Wygant, who represents Richard Batt, and Mike Matisich, who represents Premier. We are all the defendants in this case. We filed a joint brief. I'll be arguing on behalf of the defendants, but if you want to hear from either one of those individual counsel, they are here today for the court. Obviously, this case has an extremely convoluted procedural history, but what I'd like to wade through and respond to a number of the items that Mr. Kehoe said, when you wade through all the fog of this case, it's very simple. The HOA was never a party to this lawsuit. There was one point where Mr. Kehoe said, well, we tried to do this, we filed a motion to intervene. That's where we start getting fuzziness, okay? The only party, the only appellant that is here are Tim and Amie Gasing. It is undisputed they don't have individual claims against any of the defendants. I understand they were raising those claims and their goal was to pursue claims for the HOA. The HOA was not named in that original lawsuit. And let me fast forward to the settlement. Okay, the case was filed in June. We settled by December, but the settlement was just on claims 5 and 6, the claims for injunctive relief, to have the 3 board defendants removed from the board. That's what the settlement provided. To answer your question, Judge Flagg, we do not agree that this case was settled. And it was never entered on the record, but it is attached to some of the pleadings. And I would direct the court to paragraph 5 of the settlement agreement. If the parties aren't able to, in good faith, reach a compromise of any disputed claims and or attorney's fees. We disputed claims 1, 2, 3, 4 in this case, the claims for damages. If this case was settled, I gotta let my counsel know, my client know, because they've been paying attorney's fees for 2 years for depositions, a trial date, all types of discovery, working sessions with the plaintiffs. The case was not settled. We settled a portion where our clients resigned from the board. That's what was settled in December of 2021. So after that, the parties embarked on this procedure to.
I'm just getting clarification. The actual claims, like causes of action, were settled, but the issue was your claims of damages.
No,
You're saying there's causes of action here that were not settled.
That's our position. 1, 2, 3, 4 were not settled.
So when we talk about 12C standard, does the journal entry go through the ones that aren't settled and determine if it meets the 12C standard for judgment on the pleadings and on the 4 corners of the pleading?
My interpretation of the court's ruling was the remaining claims that we still had a trial date for. You don't have a trial date if a case is settled. The trial was set on those remaining claims. We not only disputed any amount of damages, we disputed whether our clients committed breaches of fiduciary duty or breach of contract in those counts. That's what was set for trial. And when the court dismissed under 12C, the judgment of the pleadings, they dismissed those remaining counts.
It sounds like the court in the entry didn't actually flesh that out. The entry says, to the extent the complaint in this matter actually remains pending, it's like we're not going to make a decision on that, it's dismissed. And then the next paragraph says, this case is dismissed as settled. Is that contradictory?
It is. Yeah, obviously it adds to the confusion of this case, but it was clear. We filed our motion for judgment on the pleading and the court dismissed whatever was left.
Do you agree that 12C is unusual at this stage? A dismissal on 12C?
I agree it's unusual, but it's not subject to something that we waived. Under, I think it's 12H, the failure to join an indispensable party can be raised at trial. This was raised prior to trial. The HOA wasn't here. And here's the heart of what the issue was. We were going to go to trial, and let's say plaintiffs won, and they would have gotten a judgment that said, you know, defendants, you have to pay X amount of dollars. Because the HOA wasn't a party, nominally or otherwise, we would have had to issue a judgment to Timoney and Gasing. Timoney and Gasing do not have claims against the HOA, against the defendants. We would have had to, my clients would have had to write a check to Timoney and Gasing and hope that they turn it over to the HOA. That's what Ackerstrom is all about. And I disagree with Mr. Keogh's emphatic statement that Ackerstrom wasn't derivative. If you read Ackerstrom, it talked about what the court reversed was the trial court's derivative award of damages to that individual homeowner that she would have had to turn around to the association. That's exactly what happened here. We couldn't proceed because the HOA wasn't a party. And at the time when this all happened, the HOA was represented by separate counsel, not Mr. Keogh. Mr. Keogh didn't represent the HOA until I believe it was around April 10th when we found out. Pursuant to a subpoena getting ready for trial, we got HOA meeting minutes. It was discussed whether HOA would even join this lawsuit in the summer of 2022. So it was an issue they were aware of, and clearly the HOA, they didn't join. They made a decision not to join. Then.
So wouldn't that be things all outside of the pleadings, like in a summary judgment motion?
Yes, but we didn't base our motion for judgment on the pleading on that evidence.
Just on on the failure to join a party?
Just on the failure, yes, it was just on failure to join the
Those
party.
claims could not survive without that essential party.
It was an essential part, yes. And so after that happens, they filed a motion to, join by interlineation. Again, we had to dust off this, I didn't even heard of interlineation. They tried to get into interlineation, but they didn't seek to intervene. They didn't seek to, under Rule 19 for joinder, they didn't seek to amend their pleadings under Rule 15 or joinder under 19. They just wanted to change the caption to put the HOA on it. It's not that simple. Our civil rules are designed around, we have parties and jurisdiction and their rules for a reason. And you don't just get to fudge it and say, well, let's just put the HOA on the complaint. That'll solve everything. No, it doesn't. And eventually, Mr. Keogh did come, after this all happened, he did start to represent the HOA. They filed a motion to intervene. They didn't appeal. The HOA isn't here. The HOA wasn't in the trial court, and they haven't appealed it here. The only appellant in this case is Tim and Amie Gasek, who did not own, and this is undisputed, Mr. Keogh has said it, we agree, they do not have individual claims against any of these defendants. And when this issue came up, I just assumed the HOA was gonna join, or they would file a motion to bring them in as a full party. They never did. And here today, I still hear no intention to seek to have the HOA be a party. He always wants to have, or appellants just want to have the individual parties.
How could claims be settled, they would be settled between parties, so that someone had to sign a settlement agreement?
And at that time, and this is where I agree with Mr. Kehoe, at the time this was filed, in the summer of 21, 3 of the defendants were on the board. We all agreed, they were conflicted. That board could not have agreed to anything because the defendants were on the board. They were on both sides. As the case proceeded, right then in December of 21, the settlement agreement, we didn't settle the whole case, we settled the issue of whether they're still on the board. We agreed those 3 defendants who were board members resigned. That's the only part of the
Was
settlement.
there a specific claim in the complaint that they resigned that was being settled?
Yes, 5 and 6. 5 and 6 were seeking injunctive relief, declaratory relief, to have those 3 board defendants resign. That's what they did. Read the settlement agreement. They resigned in December, it was New Year's Eve, I remember it. December 31st of 2021, they resigned. After they resigned, they're not on that board. That board's not conflicted. It's all made up of non-party defendant homeowners. Nothing could have stopped them from joining this case.
So what you're saying the trial court, what seemed to me was doing in their order that's been appealed is A, confirm the fact that claims 5 and 6 have been settled and dismissed with the agreement,
Yes.
and otherwise the remaining claims are being dismissed as not sufficient under civil rule 12B.
Because the right party was not there, absolutely.
And that makes everything final at that point, because up till that point, the settlement agreement had not been approved by the court.
Exactly. It's a final order because everything had been resolved.
Where in the final order does it say that the judge is dismissing this case pursuant to 12C? Or conduct any kind of 12C analysis?
I don't think it does. I mean, he went, it's not just a journal entry. I mean, he went through it. I mean, it's multiple pages long. He's explaining his reasonings.
Does he even say that he grants 12C?
I think he said he granted a motion for, if I believe the language correctly, it's he granted the motion for judgment on the pleadings. I don't think he cited the rule and subsection of it. And again, to be clear, when the motion was filed by plaintiffs, by Tim and Amie Gasek, to add the HOA as a nominal party, they didn't seek to add them as a full party. They didn't try to amend their complaint. They didn't file a proposed amended complaint. None of that. They just wanted to, and that's why they kept using the term interlineation. Interlineation is just when there's like a typo. It's an old concept. it's described as almost obsolete. I had to go to Oger to cite something even discussing, I've never cited Oger in my life. But it's described as obsolete, but it shows what they wanted to do. They wanted them in, but only nominally, and they should have been a full party. They owned the claims, they weren't conflicted, they needed and should have been at the table. But yet, there's two individual plaintiffs, homeowners, were trying to drive the litigation even after we raised the issue. I'll be really honest, when we raised this issue, I thought they were gonna do it. I thought it was just, okay, we raised the issue, they're gonna come in, but they didn't. And they can't go back and do it now. They had their chance to add the HOA back when this issue was raised in, I get my years wrong, 2023. And the HOA was not conflicted, and they chose not to enter this lawsuit. So the person who owns these claims for damages, and again, we dispute the amount of damages, and we dispute whether any of our defendants, our clients, are even liable on any of those counts 1 through 4. But the party to whom that answer is owed to is the homeowner association, not the individual plaintiffs. Their need to pursue this derivatively ended on January 1st, 2022, the day after that settlement signed. So those conflicted board members were off. Lastly, I want to address the issue of spoliation. It's to me, it's always been just a misleading argument to say there was spoliation. After the settlement was signed in December 31st of 2021, we embarked on this whole process where we turned over 10 boxes. We turned over data, anything we had, we turned it over. We're not sitting on any documents that haven't been turned over. At one of the hearings, and we've got 3 different attorneys for 3 different clients, one of our team said, look, if there's anything left, we'll turn it over. And they've taken that to say that, oh, there was something that hasn't been turned over. No, if there was anything that we haven't turned over, we'll make sure you get it before trial. There's nothing that has been willfully destroyed or anything that would support a standalone claim for spoliation. They're not asking for a
1 minute left in your time, Council.
What'd you say?
1 minute left.
With that said, unless the court has any questions or questions of my colleagues, we would ask that the judgment of the trial court, and again, we're talking about, did the trial court err? And at the time it was in front of the trial court had an HOA that didn't join, plaintiffs that didn't want to join the HOA, they weren't there, and they were faced, the trial court cannot go forward and issue a claim for remaining damages and tortious claims and breach of contract claims when the party that owns those claims wasn't there. So the trial court did not err in that ruling, and it did not abuse its discretion in denying those motions to intervene. Thank you.
Well, I think we've heard that the defendants have buyer's remorse. What I didn't hear in that 15-minute argument is why they opposed the motion to amend, and whether you use the word interlineation, whether it was a pre-civil rules concept, is academic. Under Rule 15, a motion to amend to add the association was made to address the concern. No answer about why they opposed it. Motion to intervene. No answer about why they opposed it. If they felt the association needed to be in the case, and I said this in my opening remarks, it doesn't matter if we agree. It doesn't matter if we have a difference of opinion about what Rule 23.1 means. It doesn't matter if we disagree about what ACASTRAN means. It doesn't matter if we disagree about demand futility. Throw all that stuff out the window. If they need to be here, there were 2 avenues to be here, and the defendants opposed both of them. And they're still here urging the court to affirm that. Why? Buyer's remorse. They want a do-over. That's what this is about. They want a do-over. They don't like the settlement, and what they learned during this investigation, discovery process is a lot of things about their client in the records that they didn't know. And as the bill got higher and higher, the agreement to pay attorney's fees got bigger and bigger, and so what they're looking for is a do-over. And that's not permissible. There is a signed settlement agreement, and that signed settlement agreement, I'm hearing for the first time that they're disavowing some provisions of that agreement, because the damage claims and the attorney fee claims are addressed all the way through fairness hearing, and there is a process for addressing the damage claims within the context of that settlement agreement. We did not do full-blown discovery. You can look in the trial court's order, you're not gonna find a discovery schedule. The parties came in and by agreement said to the magistrate, this is what we're gonna do. So the whole pretrial discovery process was amended within the context of that settlement agreement solely for the purpose of an expedited resolution of the damage claims and the opportunity to object to the fees if they chose to do that. So that's really what we're dealing with here. And I guess the question is, if they really felt the association needed to be a party, why wasn't it raised before the settlement agreement was signed? Why do we hear about it literally 3 days before trial? And that is really the issue. There is a settlement agreement, and what the defendants are trying to do is to avoid that settlement agreement through these machinations about whether the HOA needs to be a party. And the simple question is, if you felt they needed to be here, why did you oppose the amendment? Why did you oppose the intervention?
Counsel, your rebuttal time is up. Would you like to briefly conclude?
Yes, Your Honor. Based on the arguments before the court, I would ask the court to reverse and remand for further proceedings. Thank you.
Thank you. And I'd like to thank both of you today for your presentations on behalf of the court. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision due on the date released, and the opinion will also be posted on the High Supreme Court website. With that, the court is now adjourned until